Professor Vasanta Seneviratne, head of the Department of the Public and International Law. I'm delighted. It is with great pleasure, and I'm truly delighted to have this, to witness this series of nationally oriented lecture series sessions of as Akalanka mentioned, it is the fourth session, and we have had internationally renowned scholars who shared their insights into very hot topics, very contentious issues in the international law. So it is I'm honored to have a legal luminary, international legal scholar in the field of international law, because when I thought about Professor Andre Nolkamper, to me, he's like a renowned international figure. It reminds me Hugo Grotius and Professor Veeramantri, who from our own country contributed immensely, enormously to the development of law. Sir, so it is, we welcome you to the faculty. And when I looked at your profile, it is very difficult to summarize it, but I will, for the benefit of the audience, we have very international audience, very academically oriented law students, and also the academics from other law teaching institutions, including the Open University of Sri Lanka. I have my colleagues also. It is my privilege to read out few accomplishments and achievements that you have made, sir. Professor Andre Nolkamper is the Dean, Faculty of Law of the University of Amsterdam, Netherlands, and in December 2020, he was elected the Dean for the second time. And now I think he's holding the position of deanship as well. So his, in terms of his, if I have a glimpse of his accomplishment, since in 1998, he became the professor of public international law in 1998 in the Faculty of Law of the University of Amsterdam, and he holds the chair from 1999. And also he has been a member of many organizations, including Center for Excellence, the Amsterdam Center for International Law, ACIL, and also in the other international top ranking international institutions in many countries. And he has been a visiting scholar in many countries, including, as I can remember, is from in Oslo, Norway. And during the last couple of years, since 2010, he has been an external legal advisor to the Ministry of Foreign Affairs of the Netherlands, and he's also member of the Permanent Court of Arbitration from 2004 through 2020, and president of the European Society of International Law from 2004 through 2007. And also he has been a member. He has had practical experience in many ad hoc tribunals. For example, the Special Court for Sierra Leone and Cambodia, and also other international institutions. In terms of his research, he has established an international argument about international rule of law. Everybody is talking about international rule of law of the country, domestic sphere, but Sir has enormously researched on the international rule of law. And of course, the intersection of international law and domestic law has been one of the main themes of his research focus, research approach, and then global legal environment being also research. And he has numerous publications, including guiding principles on shared responsibility in international law as a profession, published by the Cambridge University Press 2017. So you have many contribution to your name, and if I read out, I will not do justice. Therefore, it is time for our audience to listen to you and to glean the best knowledge, experience, insights that you have about international law, and the discourse of the application of international law into the domestic sphere is a very hot topic in Sri Lanka, and it will remain for in the future as well. So I think, sir, in view of the current situation and also the contentious issues that the countries in the world are facing, this discourse is timely, and floor is yours, sir. Please contribute to the discussion forum of the Faculty of Law. Thank you.
Thank you very much, Dean. Thank you very much to the organizers of the webinar. It's a great pleasure for me to address you and to talk with you on this very important topic, which is a topic of international law. At the same time, it quintessentially interacts with domestic law. So we really should think about this topic in connection with the domestic legal system. So it's a great pleasure that, coming from where I'm sitting in Amsterdam, we can address this topic in the context of Sri Lanka and the legal questions that may arise there. So perhaps a bit of additional background on where I'm coming from, specifically on this topic. So for 15 years or so, I've been the editor-in-chief of the Oxford Reports on International Law. They publish every week new cases on international law in domestic courts. And we started with this 15 years ago. We have now well over 2,000 cases. I note that as of now, we only have one case, the famous or infamous Stingarasa case from Sri Lanka, in that collection. And we definitely, at some other moment, should look at the possibilities to have more case law from Sri Lanka in that database. But that collection of 2,000 plus cases do allow us to have a snapshot from the approaches across the world on how states, how legal systems deal with international law in the domestic courts. And they provide us with a perspective from which we can compare what the experiences in Sri Lanka, India, South Africa, other parts of Asia, Latin America, Africa, and Europe. And that provides a very rich experience. And I will try to share some of the insights from that. I think one other point to recall is that indeed I chaired a committee of the International Law Association that in 2016 finalized the principles on the engagement of domestic courts with international law. That was a report adopted by the International Law Association based on country reports, including one report on Sri Lanka, that provides a very rich overview of the different ways in which domestic courts across the world engage with questions of international law. And I will draw a bit on that report when we go through the various topics of today. So the topic of today, I think I cannot overestimate how important this is, how important the domestic reception of international law is. And let me try to share the screen for a second.
Yeah, it's coming through, sir.
Yes, but not yet quite a screen that I would like, but let me see if I can get that.
Yeah.
Have you this?
Perfect.
Oh, yes.
Perfect.
Okay. Yeah. So this quotation from Antonio Cassa is one that I personally always find a very important starting point for when we think about this topic. So the late Antonio Cassa, of course, former president of the International Tribunal for the former Yugoslavia, and very renowned international scholar, wrote, very rightly so, that most international rules to become operative need to be applied by state officials or individuals within domestic legal system. Because international law, we should not think of international law as purely a normative system above the states. For its operation, for its effectiveness, it relies on domestic agents. Not only courts, also the executive, the legislature, but definitely including the courts. At the same time, we know that there is a lot of pressure worldwide, a lot of resistance, sometimes even, against the full application of international law. Let me, but just by way of example, show you this slide from a few weeks ago in the Guardian newspaper on the events in Poland, where the highest court in Poland ruled that EU law is incompatible with the Polish constitution and therefore cannot be applied domestically. This is about European Union law, but the same type of message can be taken from Poland and many other states in relation to the European Court of Human Rights, in relation to the Human Rights Committee. And then we can easily see many examples from Asia, from North America, where courts similarly have taken a somewhat reluctant position towards the application of international law. So it is in that frame of, on the one hand, the critical importance of the domestic application, including the domestic judicial application of international law, on the one hand, and the difficult state in which international law finds itself in its entry in domestic legal systems, like the Polish example illustrates, on the other hand. It's against the background of that tension that I want to address my talk. So what I will do is to make some observations on the legal principles, the legal perspective that applies to the domestic application of international law, domestic judicial application of international law, in particular in human rights law. And then I will refer here and then to the practice of Sri Lanka. Of course, I'm not a specialist on the law of Sri Lanka, nor on the constitution of Sri Lanka, but I did, over the years, read up quite a bit on the relevant developments in Sri Lanka. So I guess for the audience of today, it will be interesting to look at this practice from this wider perspective of international law. Now, I will structure my talk by drawing upon the final report that I mentioned before, the final report of the International Law Association report on the principles on the engagement of domestic courts with international law, a group that I shared together with Professor Shaney from Hebrew University, Israel, and Professor Tsanakopoulos from University of Oxford. And in that report, finalized in 2016, we drew upon the practice of many, many states across the world to take stock of where are we now, then in 2016, but now in 2021, with our thinking on what we can expect, what we should expect from domestic courts in the application of international law, from the perspective of international law. And this is a critical message that I always have to stress. You can look at the practice of domestic courts in Sri Lanka or any other states, of course, from the angle of domestic law, domestic constitutional law, the separation of powers, the enactment of particular laws within the state. Of course, that is perhaps even the starting point, because the courts derive their power from domestic law, from the domestic constitutional law. And one can never forget, one should never forget that the courts are embedded and derive their legitimacy from the domestic political and legal organization. At the same time, we are all, and the states are, and the courts are part of the international community. And as I said, with my reference to Professor Cassa, international law, which consists of the rules that we together, that states together have developed, have enacted, need to implement for the benefit of the interest of the global community, the global international community. That law provides the overarching normative perspective for thinking about and for assessing what domestic courts do in the field of international law. So this report, based on this worldwide practice, eventually focused and concluded from the practice that there are three types of engagements. Three types of engagements in which domestic courts operate, give effect, or sometimes do not give effect to international law. The first is alignment, in which national courts seek solutions that are in line with, that are compatible with obligations and rights under international law. I come to that in a second. Then there's a separate basket that the International Law Association called avoidance, where domestic courts on various
I think it looks like Professor is muted. Professor, you are on mute. You have to unmute you.
Am I still muted now?
Yes. Now
Can you
you
hear
are.
me now?
Yes, we can.
Okay, did you, I was just recently muted, right? Or have you?
You just started to explain the three types of engagement.
Yes, okay. Okay, yeah. So with contestation, then the third form, I think the Singarasa case from Sri Lanka actually might well be placed in that basket, where domestic courts take an approach that challenges, that does not accept and indeed contest the application of international law. So what I will do is to go through these three categories and make some observations on how we look at them from the perspective of international law, and how I, looking from a far distance from Amsterdam, look at some of the practices that I've seen in Sri Lanka or the wider region. So let's first look at alignment. So alignment of domestic courts with international law. Now, alignment I will define as the practice of domestic courts where, irrespective of the prescriptions of the domestic constitutional framework, they attempt to align with international law, or at least to harmonize domestic law or practice with international law or regulation. Now, this is from the perspective of international law, of course, the preferred situation. And I think it's an important point to emphasize that from the perspective of international law, it is proper to say that states, but also courts, domestic courts, which after all are state organs, are obliged to bring domestic law in line with international law. Now, some treaties specifically provide for this, but my proposition would be that this reflects a more general principle of international law, that states, and a fortiori state organs, need to take the actions that are necessary to ensure a full performance of international obligations. And I guess that Article 27 of the Vienna Convention on the Law of Treaties and Article 3 of the Articles of the International Law Commission on the responsibility of states for internationally wrongful acts, which provides that states cannot rely on domestic law to justify non-compliance with international obligations, that these provisions provide support for that overarching obligation of states and state organs to ensure the alignment of domestic law with international law. So this is not neutral. It cannot be contingent on domestic law. I think this is really the, in principle, the desired perspective. Now then, if we delve a bit closer into this, so how does this work? How do domestic courts actually try to ensure alignment? So I will distinguish 5 types here, and I will go through them one by one. Perhaps the ideal form, the most effective form, is what we call direct application, where courts simply could give direct effect, in cases where domestic law leaves a gap, or cases where domestic law might conflict international law, that domestic courts might then apply international law, thereby ensuring alignment. But we know, of course, that this is a situation that only in some states across the world is possible. It is definitely possible for many rules of international law in the country in which I am sitting, the Netherlands. It is possible in France. It is to some extent possible in the United States of America. It is certainly possible in a lot of Latin American states, Brazil, Argentina, Costa Rica. It is possible in part of Africa, in particular Eastern Africa. But it is not possible in many, many other states in the world that have adopted the so-called dualist legacy, often a legacy from the United Kingdom legal system. And my reading of the case law, sometimes inconsistent, sometimes not so clear, and my reading of the scholarship from Sri Lanka is that at least for treaties, this indeed will be the position in the courts of Sri Lanka, where unless there is an enactment by domestic law, courts will not be able to give direct application to international law in those cases where there's a gap, and certainly when there's a conflict with domestic law. And my understanding and reading is that this is different from customary international law. But then again, we also know that there are not so many cases where courts actually rely on customary international law in order to ensure the direct application of international law. Now, I think this is a topic on which we can reflect for 1 second, in particular in relation to human rights. Because we have to think back, why is it actually that the so-called dualistic states like the United Kingdom, Australia, New Zealand, but then also probably Sri Lanka, do not allow for direct application of treaties that are not incorporated in domestic law? And the classic answer that I always teach my students, the classic answer is related to the separation of powers and to the way the powers to negotiate and ratify treaties are arranged in a particular state. And then, of course, the story goes that in those states where the executive has the power to negotiate a treaty, to sign a treaty, and also to ratify a treaty, without parliament playing a role, that in those cases it would be undesirable to give the courts the power to apply treaties directly when parliament has not been involved. And that if we wish to change this, if we wish to make it possible that the states in that category of dualist states would allow for direct application as we do in the Netherlands, that is only possible if we change the procedure for the negotiation, signature, and ratification of treaties, providing for a greater role of parliament. Now, that is the classical explanation. But one should ask the question, and I think that is a very material question for the topic of today, with a focus on human rights. I think it's also a material question for the practice of Sri Lanka, whether that argument really holds much value when we speak about human rights. Because a large part of the globally applicable human rights of the United Nations covenants certainly can be covered by the category of customary international law. Not all of them, but definitely a significant portion. And for those rules of human rights law that are parts that belong to customary international law, the traditional argument that courts could not apply them directly because they were negotiated, signed, ratified by the executive does not hold much value at all. And I would rather say that in those cases, in the dualistic legal systems, they could actually be applied directly. They should be applied directly, but then under the heading of customary international law. And I think from my understanding, my reading of the practice in Sri Lanka is that this fundamental question, under what conditions can courts give direct effect, is one that might merit further thought, also in relation to customary international law. Now let's put that aside for a second, that's under the heading of direct application. then it is quite clear from a worldwide perspective that the most important process, the most important technique, the most important way in which domestic courts give effect to international law definitely is consistent interpretation. So here in a quote from the United Kingdom House of Lords, this is from the Bryant case on the application of the European Convention on Human Rights. And this is language that one finds all over the world, that in construing a provision that is ambiguous in the sense that it's capable of a meaning which either conforms to or conflicts with the convention. The reference is made here to the European Convention on Human Rights. The courts will presume that Parliament intended to legislate in conformity with the convention, not in conflict with it. Hence, importantly, the courts then will interpret, give meaning to a domestic law in conformity with international law. And the result, the outcome, then indeed is in line with international law. Now, from the pieces that I read, the cases that I've seen many examples from the courts in Sri Lanka in which indeed they engaged in consistent interpretation in the field of human rights, in the field of torture, where domestic laws were given a meaning that was in line with what was required by international law. And this cannot be emphasized enough, because the point is here that even though Sri Lanka and many other states are formally, at least as construed by the courts, dualistic in relation to treaty law, in actual practice, much of the disadvantages and the drawbacks thereof are overcome by the practice of consistent interpretation. And if I read all the case law that I've seen from Sri Lanka, but I could say the same for India or from Canada or Australia. If one reads all the case law, for me, the many cases where courts engage in consistent interpretation with a view to give effect to international law are far more important in terms of quantity and quality than the relatively few cases where courts were not able to apply international law directly. And for me, this practice of consistent interpretation shows that courts across the world, and also in Sri Lanka, have this international attitude and approach, and that at least to some extent it's part of the legal culture to bring domestic law in line with international law. Now, digging a bit deeper on this topic, the question is, why is this so? What explains this practice? Why do courts engage in this practice of consistent interpretation? I think by and large, there are three possible explanations, which are not mutually exclusive. So one is that some constitutions explicitly provide a mandate for the courts to consider international law in the interpretation of parts or the entirety of domestic law. So the example here is from Article 39 of the Constitution of South Africa, which explicitly provides that when interpreting the Bill of Rights, a court must consider international law. There are many other examples. And actually, I've seen in some of the scholarship on Sri Lanka proposals that perhaps the Sri Lanka Constitution should similarly provide for should contain a similar type of provision to expressly mandate the courts to engage in consistent interpretation. So this is one justification, but also one explanation of why courts engage in the practice of consistent interpretation. The other one, second one, which was referred to in the judgment of the House of Lords and later the Supreme Court of the United Kingdom, is that the courts wish to honor the intent of the legislature or the executive, which drew up the treaty. So this was in the previous slide, indeed, where the House of Lords said the courts will presume that Parliament intended to legislate in conformity with the convention, not in conflict with it. You can have the same type of reasoning for the executive, in those cases where the executive negotiated and signed and sometimes ratified a treaty. And that presumption then only will be broken when the legislature or the executive expressly displays the intent to deviate from the treaty. Of course, under domestic law, under domestic constitutional law, most legislatures or courts will be able to do so. But the point is that only when they do so expressly, the presumption of intent can be broken. So this is a second justification and explanation at the same time of this massive worldwide practice of consistent interpretation. There's a third point to make, and that is from the angle of international law, perhaps the most important one. And that is that this practice, more than anything else, allows courts to give effect to international law. So this is where I started with my opening comments on alignment, that from the perspective of international law, this is not neutral. It is not so that courts can either go left or right. From the perspective of international law, the overarching principles is that states and their organs, including the courts, should do what they can do within the powers to give effect to international obligations. And there are quite a few examples across the world that recognize that fundamental principle. The example given here is from Botswana, where the Botswana Court of Appeals said back in the 90s that Botswana is a member of the community of civilized states, has undertaken to abide by certain standards, and it would be wrong for the courts to interpret the domestic legislation of Botswana in a manner that would conflict with these international obligations that Botswana has undertaken. So here, the practice of consistent interpretation can be explained and justified by international law itself. Now, in actual practice, these three justifications may come together, but I think it's important to emphasize the perspective from international law. One final comment on this, again, this quite massive worldwide practice that also extends to Sri Lanka on consistent interpretation. Of course, there is one drawback here. There is also a more political dimension, because this inevitably, this practice of consistent interpretation may raise questions of the separation of powers, the separation of between the powers of the courts and the executive, and the separation of powers between the courts and the legislature. And this is not so problematic if it concerns rather technical interpretations of particular provisions of domestic law in the light of international law. But there are many examples that show that courts can, by the practice of interpretation, actually assume more powers, move powers a bit away from the legislature, and engage in what sometimes has been called judicial lawmaking. So two recent examples from the Netherlands, from the Supreme Court of the Netherlands, the case of Urgenda against the Netherlands. There was a quite famous case where a NGO sued the Netherlands for its climate change policy, and where the Supreme Court eventually relied on international law, including soft law, including commitments by the conferences of the parties to the Climate Change Convention, which are not binding, to interpret provisions of domestic tort law. Well, the point here was that the legislature had chosen not to give effect to these international documents. The courts then could not possibly apply them directly, but the court used them to give effect to an extremely wide concept on a domestic tort law, thereby in effect assuming or taking away a power that was sitting with the legislature. And quite a few commentators in the Netherlands have actually said that the court here may have engaged in a practice that actually was within the power of the legislature. And the same holds for the case at the bottom, which was a case by the District Court of The Hague, not a case by the Supreme Court, District Court of The Hague, of a NGO against Royal Dutch Shell. There was also a landmark case in which the court held that the Royal Dutch Shell was obliged to take certain measures to contribute to climate change reduction policies. Just like the Supreme Court, the District Court came to the conclusion by drawing on international soft law to interpret quite open, ambiguous provisions of Dutch domestic law, which, according to some people, would have been a question for the Dutch Parliament. So the point being that in this practice of consistent interpretation as a form of alignment, which again is worldwide, it's highly important, but in at least part of the cases, we see that this triggers in complex questions of the relations between the political and the judicial branches. And international law is then one tool, one language, one might say, one set of principles to mediate in that often complex relationship. Okay, I come to my third form of alignment. This is what we called in the work of the International Law Association consubstantial norms. Consubstantial norms. Now, this is a difficult term, perhaps, but what is meant here is that in many cases, in many states, and Sri Lanka definitely is a case in point, that in Sri Lanka, many of the international rights and obligations in the field of human rights are, of course, also made part of domestic law. They already were so, I understand, before the Singharasa case and certainly in later enactments. And that means that human rights law leads, one could say, a double life. They exist as international norms at the international plane, but in substance, they have been made part of the domestic law, constitutional law or otherwise, of states, including Sri Lanka. So what the courts then in many cases will do when they are faced with a question of freedom of expression, freedom of religion, torture, or any other human rights question, they often will apply technically a domestic norm in the constitution or otherwise. And they will not, but they need not apply international law as such. They could even decide the case purely on domestic law, yet, and that is the important point, yet the outcome will be the same and will be in line with international law. So the general point here that should be made, is that yes, international law requires that courts, domestic courts, adjudicate their cases in line with international law, so as to ensure that international obligations are performed. But at the same time, international law is neutral, entirely neutral, as to the specific way in which those obligations are performed. And international law is entirely neutral to the possibility that courts might decide these cases purely based on domestic law without reference to international law whatsoever. This is all fine as long as the outcome is secured. There's only one footnote that I want to make to this practice, which is quite widespread. There are many cases, again, on freedom of expression, torture, that are purely decided on the basis of domestic law. That is totally fine from the perspective of international law, but there's one caveat, and that is that we always have to keep in mind that domestic courts are not only at the receiving end in terms of their role in applying international law, giving effect to international law, but thereby they also contribute to the further development of international law, to the interpretation, to the evolution, to the dynamic evolution. And we know that international law, and perhaps most of all human rights law, is not static. It evolves over time in line with the developments and expectations of the communities in which it is applied. And this dynamic role, this law-shaping role of domestic courts is a very important one from the perspective of international law. And I name it here, I mention it here under this specific item of consubstantial norms, because if one recognizes that important role of domestic courts, I believe it is important that courts also speak the language of international law. Speak the language of international law, which also makes it possible that the courts enter a dialogue, engage in a conversation with courts in other jurisdictions, with international bodies, with the Human Rights Committee, with the European Court of Human Rights, with the International Court of Justice, and so on and so forth. But that will be, and that's my point here, that will be far easier. It will be far easier if courts do not just refer to domestic law on freedom of expression or freedom for torture, but also frame their arguments, their legal arguments, their decision, the motivation underlying their decisions in international legal language, and expressly motivate their decisions in terms of interpretations of international law. And only then will it be easier and stronger, will their role as norm developers be stronger. So consubstantial norms can be used to give effect, but I would make a strong argument that the power of courts to shape international law would be assisted by engaging in an express conversation with the international law dimensions of these norms. I come to my fourth topic, my fourth form of alignment. This is what in the report of the International Law Association we called hyper alignment. Perhaps a somewhat strange term, but what is meant here is that sometimes courts engage in a practice that goes beyond what is required and what can be explained and what can be justified by international law, strictly token. So two main examples. One is, and I think I have slides on this. Yes. So one, and this is from the, of course, the case that many of you will know, the Bulan Kulama case, where the court referred to the declarations of Rio de Janeiro, 1992, and the Stockholm Declaration of 1972 on the protection of the human environment as a basis for their decision. Now, of course, strictly token, international lawyers would say, well, the declarations of Rio de Janeiro and Stockholm are not legally binding instruments. They're not treaties. They definitely are not in whole part of customary international law. So one could not really say that the courts of Sri Lanka are legally obliged to align themselves, to align the practice of Sri Lanka with these instruments. So it is not ordinary alignment. Nonetheless, in this very interesting case, and I reread it actually for purposes of this webinar, this very interesting case that deserves to be read in many other places. The court gave actually legal weight, legal effect to these documents when it said they may be regarded merely as soft law, but even such soft law will be binding if they have been either expressly enacted or become a part of the domestic law by adoption by the Superior Court of Records and by the Supreme Court in particular in their decisions. So the point here is that these type of instruments, not legally binding, if they are not enacted in domestic law, which of course is always possible, then the courts still could include them in their arguments. This would be an example of going beyond what is required by international law, therefore the term hyper-alignment, but thereby also the courts certainly make an important contribution to the development of international law. And in effect, I do think that this is an example where you enter the field of judicial lawmaking, precedents, where the legal development in Sri Lanka, but thereby also internationally, is actually taken on board, assumed by the courts in their powers, the powers that they have as interpreters, but also as shapers of the law. Again, a point that relates to the separation of powers. And I cannot emphasize enough how important this is, because the cases that I mentioned earlier from the Netherlands, so these two cases, the court did not expressly refer to the cases from Sri Lanka, but the type of reasoning in which the court here engages with international soft law is quite similar. And I do think this worldwide trend where courts within their respective power can contribute to the development and the application of international standards adopted by the international community, even though non-binding, is a very relevant one for the further development of international law. Now, I said there were, going back to the hyper-alignment, there are two forms. So one is the one in which courts engage with soft law, like here the example with the Rio de Janeiro Stockholm Declaration. The other example that is quite common in common law states, and I've seen also quite a bit in cases from Sri Lanka, is the practice where a court of Sri Lanka would refer to the case law of, for instance, the European Court of Human Rights. Of course, there's no way in which the decisions of and the judgments of the European Court of Human Rights will be binding on the states of Sri Lanka or the courts of Sri Lanka. At the same time, courts do recognize that the practice of international courts and institutions, even though formally not binding on that state, that they are relevant for the interpretation, the construction, and the development of international law. And that a broad perspective of the role of domestic courts in the international system, where they engage, where they have to engage in a continuous dialogue with other bodies, and they have to be aware and have to look at the interpretations of other bodies, that indeed justifies, of course, with all limitations stemming from their specific mandates, justifies to look also at pronouncements of courts that technically are not binding. So all of this is covered by this category of hyper-alignment, where courts go beyond what they are strictly token required to do by international law. Finally, my final point here is what we call overriding alignment. Now, this refers to the difficult but very important category of cases where there is a conflict between domestic law and international law. So this brings us directly to the very fundamental problem of supremacy of international law. So again, for clarity, the situation we're looking at here is where the state has an obligation under human rights law that limits ourselves to this. And when domestic law conflicts with that international obligation. And then the question is, which one prevails? Now, from the perspective of alignment, of course, one would say, the question will be, can domestic courts then, despite this conflict, nonetheless give effect to international law? Now, this, of course, this is a very fundamental problem of international law. I have included here a quote from Sir Gerald Fitzmaurice, who wrote that the principle of supremacy is one of the great principles of international law, informing the whole system and applying to every branch of it. And clearly, the entirety of the law of treaties, of the law of responsibility, but also of specific fields like human rights, like investment law, like trade law, they can only be understood, but they also can only work based on the notion of the supremacy of international law. I would even say that the entirety of international law can only survive, can only fulfill its functions if we fully accept the principle of supremacy. That is, international law prevails over a conflicting rule of domestic law. But of course, and here comes the twist. The twist, of course, is that this principle of supremacy, where international law prevails over domestic law, does only apply in the international sphere. It does not, international law cannot, out of its own force, create supremacy at the domestic level. And a very simple explanation for this is that if we look from the angle of customary international law, we simply have to recognize that the practices worldwide are too diverse, that the practices of states that allow supremacy domestically, that next to these practices, we have many states where this is not possible. So in the Netherlands, my state, we fully embrace the supremacy of international law. In the Netherlands, international law even prevails over the constitution of the Netherlands, which is one of the very few states in the world that has taken that step. So a court, it does not happen a lot, but if it happens, it can happen. A court can even apply an international convention on human rights by setting aside a provision of the constitution that conflicts with that rule of international law. But next to that, we have many, many states, of course, where this is not possible. And it is this very diversity that explains that international law is supreme in the international fields, but in the domestic fields, that supremacy does not hold. And that domestic law is supreme in the domestic sphere. And then, of course, domestic law itself can grant supremacy to some rules of international law. But that then is done by virtue and by the power of domestic law, not by international law. So it is the national constitutions of the Netherlands that says we accept domestically that international law is supreme. My understanding of Sri Lanka is that in a limited extent, for investment treaties, there is a limited supremacy accepted over statutory law, though not over the constitution. But that is not extended to other fields of international law. So this is, I believe, from the perspective of the effective application of international law, a very important question, how the domestic law of states, and that also holds for Sri Lanka, how that deals with the question of conflicts. And in what cases, particular parts of international law, and I mentioned investment law, but of course human rights law might be the far more important category, are actually supreme over domestic law. If you look to Latin America, there, large parts of human rights law actually have supremacy over domestic law, over domestic statutes. And the courts are allowed to strike down statutes that conflict with international human rights law. This is not possible in many other states. And I believe from the perspective, the long-term perspective of making international law more effective, this is a question that really deserves full attention. With one caveat, though, one limitation that we should face, and that relates already a bit to the concept of contestation. That as international lawyers, we of course are trained and raised by believing in the quality and the importance of international law, and that if there's a conflict with domestic law, yes, of course, international law should be supreme. And of course, states should never rely on domestic law to set aside international law. But one should raise the question whether this changes if international law itself is not unproblematic, and if international law itself lacks the rule of law quality and the democratic quality of domestic legal orders. And of course, the case in point here is the famous or infamous Cadi judgment of the European Court of Justice, in which it decided that a rule of European law, a fundamental right under European law, had priority over a resolution of the Security Council, because the Security Council itself was not embedded in, let's say, a rule of law quality. And then, if one accepts that, the question is supremacy of international law always a good thing? Or do we need to rely on domestic law as a final safeguards? Now, I come to that in a second in my closing observations. So going back to my overall scheme, I've said there are three types of engagements. First of alignment, and I've set out 5 types of alignment, 5 types by which courts can bring domestic law in line with international law. And I made some observations on the questions that may arise. Now, I will be far briefer on the other 2 points, the other 2 types of engagements. The second one, and I move forward a few slides, is avoidance. This is a practice where domestic courts can or could have applied and could have referred to international law, but do not do so and choose to bypass the question or dodge the question of international law altogether, simply because they do not want to engage in the international legal argument. Now, as such, and I think it's important to note, as such, this is not problematical as long, of course, as the outcome is in line with international law. And this refers to the cases that I already mentioned, cases where domestic law, the Constitution, for instance, has particular fundamental rights, and courts can simply avoid reverting to the international law and simply decide the question on domestic law, which can be fine. But then there are also quite a few cases For instance, when courts refer to the political questions doctrine, when they refer to immunity, when they refer to the principle of comity, or the principle of separation of powers, there are quite a few techniques that allow a court or that provide arguments for a court not to engage in a full discussion of the international legal questions before it. Now, this, of course, depends very much on the context of the specific legal system where this is raised. But let me, as a general observation, mention that unless there are good reasons otherwise, for the development and interpretation of international law, it would be beneficial if courts would actually address the questions of international law that are before it, so as to help to shape a meaning, an interpretation, and understanding of legal questions across states. I put this within brackets now, and I move to my last point, also for reasons of time, the practice of contestation. Now, this is a very important one. It also relates to the example I gave in the very beginning from Poland, where the Polish highest courts have said they will not apply, not give effect to certain rules of European Union law, where this conflicts with the Constitution of Poland. Now, this, I think there are two ways to look at this practice. One, problematic, which I term local contestation, but there's also a more internationally minded contestation. So I take it that the local contestation really is when a court challenges or contests a particular international obligation and says, we're not going to apply this because we're giving priority to domestic law and because this international obligation does not conform to domestic law. And we prefer the domestic outcome. This, of course, can be justified from the perspective of domestic law, but from the perspective of international law is inherently problematic. I think that needs no further discussion. The more interesting one is what I call here internationally minded contestation. And here I have the example from Italy. Italian Constitutional Court, in the case of Simociani against Germany. So this refers to the case law that arose out of compensation claims for the Second World War, where first the Greek courts and later the Italian courts denied the immunity of Germany and allowed cases to move forward where relatives of victims from the Second World War claimed compensation from Germany in the courts of Italy. Germany then went to the International Court of Justice, so Germany against Italy, jurisdictional immunities of the states, and Germany said, yes, but we are immune. We cannot be brought before the courts of Italy. The International Court of Justice ruled in favor of Germany and indeed said, yes, this is a question of state immunity. But then the Italian courts said, no, the fundamental principles of human rights law are jus cogens, and they prevail over the international law, the international principle of immunity. And they argue this based on the Italian constitution. Now, you could look at this as a case of a pure conflict between the domestic law and international law, and that the Italian courts gave priority to domestic law, and that this is a problem from the perspective of the international legal order. All true. At the same time, we have to recognize that the principles to which the Italian court referred in substance were also principles of international law. Because the same principle, human rights principles that justify the court to set aside immunity are recognized in international law. So you can actually say that hereby the courts gave an internationally justified contestation to the outcome of the case in the International Court of Justice. And my reading of this famous Cadi case in the European Court of Justice, by which the European Court of Justice decided not to give effect to a Security Council resolution based on the fundamental rights contained in the Charter of Human Rights of the European Union, that also is an internationally friendly interpretation, because those very international human rights are also accepted at the international level. And thereby, and this is an important point, I do believe that this practice of contestation, which in principle is problematic, if the courts argue this based on an argument of international law, thereby they also can help to solve this dilemma, going back a few slides, this dilemma that yes, we have to recognize that some rules of international law are problematic. Sometimes these rules of international law conflict with other rules of international law that protect human rights. But here, domestic courts have a very important role in basing themselves, in justifying themselves based on human rights law, and thereby challenging other rules of international law. Now, my final slide then is from my reading of the Cassa case, of course, familiar to all of you. I think this case can be used for many dimensions of what I discussed in my talk. Definitely, it is relevant for dualism in relation to treaties. It is relevant for the separation of powers and power of the president in relation to treaty signature and ratification. But it's also relevant and often mentioned in the literature in this field of contestation, because it is a case where the court expressly rejected the legal weight, the legal relevance of a decision of the Human Rights Committee, a body established by an international convention. And the question then is, how do we assess this case? I would say that in contrast to this Italian case, it is very difficult to read the Cassa case as a case that is internationally friendly contestation. There is no language or little language in that case that justify this decision by reference to international law. Rather, it is inward-looking, more nationalistic interpretation or approach to contestation by which international law is challenged based on the conflict with domestic law. So from that angle, I do think, and I'm closing my slides here, from that angle, I do think that this case is quite problematic and does not fit well in, let me see if I'm back here. Yes, does not fit well in line with international law friendly practice. I will conclude. So from my reading of the practice of the courts in Sri Lanka, the scholarship I've read about is really that I see a tension between two different phases of this practice. I think much of the practice that I've seen, all of the practice on treaty ratification, so the position of Sri Lanka in the international fields, the widespread practice of consistent interpretation where domestic courts are interpreted in line with international law, that shows a side of the Sri Lanka practice that very much fits in this international law friendly approach that is very important for international law to move forward, to be effective and to fulfill the interests of the international community. At the same time, there are limitations in the domestic legal system relation to the limitation of the power of the courts to give priority to international law, the limitation of the powers of the courts to review the validity of statutes under the Constitution and also under treaties, the lack of possibility to give effect directly to treaties when there is a gap in international law. And on top of that, I guess when one reads the various reports of United Nations treaty bodies that draw attention to particular human rights problems in Sri Lanka, there also is another side that coexists with that international law friendly side, where the courts are limited in their possibility to adjudicate questions of international law in line with what international law requires. It's difficult for me to assess whether this is up to the courts or whether it's a matter of the constitutional limitations of the courts. My overall reading is that by and large, the courts have taken a very international law friendly approach within their powers. Leaving aside perhaps cases like Singarasa, which are definitely more problematic. But it's more the limitations of the powers by the Constitution, by other branches, that limits the possibility of the courts of Sri Lanka to provide the contribution to the full implementation and thereby also development of international law that serves the interest of the wider international legal order. I will stop here and I will be happy to address any questions that may arise. Thank you.
Yes, thank you so much, Professor, for that wonderful discussion that you just made. And it just showed us like how much we can critically evaluate this relationship between international law and domestic law. So we have gone to places that where we have not gone before. And I think the others can also agree. And now I would also like to invite Professor Vasantha Seniviratna, who is also a member of this constitutional, I think, constitution making committee. So she can also share in her experiences regarding where the Sri Lanka is headed in this relationship between international law and domestic law. Dear Madam, can you explain as to the Sri Lankan stance currently?
Thank you very much. Let me begin with thanking Professor Noel Kamper for very comprehensive discussion, which flag almost all the important aspect of the discourse on domestication of international human rights law at the domestic level. I am delighted to listen about the comparative examples that Professor could bring in to highlight the points that he was flagging in, particularly his insightful analysis about the Sri Lankan case law, particularly Bulankulama judgment. Always we cherish this Bulankulama judgment as a landmark judgment where Sri Lankan judiciary could prove the creeping towards monism rather than being strictly dualist, to give the benefit of cross-fertilization of international law for the betterments of the lives of the people in the country in terms of the ratification of treaties as well as customary international law. So thank you, Professor. I think I find many of our sister law teaching institutions, the academic staff, our own staff, our students have joined. I believe that they have immensely benefited of your insightful analysis. You have taken extra, effort to compare and to bring examples from our jurisdiction. That is really appreciated. Moving to what you asked, Akalanka, international law does not dictate or command its terms to one sovereign state, because that is the sovereign state that should open their territorial frontiers for international scrutiny based on their own consent. We call it pacta sunt servanda. The creators of international law are the states themselves. You know, nothing comes from the sky. The states get together and they, engage in endeavoring the making of international law, either as treaties or by their own state practices and opinion juries as customary international law. But the matter is, when it comes to the application and implementation of domestic law, the application of international law at the domestic level, then they try to block the domestication of international law, either passing the onus on the legislature to pass and enable legislation in countries like us, and whereby blocking the judiciary in invoking those international obligations already undertaken by the states when the victims who wish to get some remedies from the international legal standards to which their country is a state party. Moving to practical points now, it is it is not a thing to hide out. Sri Lanka is under strict international scrutiny nowadays. UN Human Rights Council has issued several resolutions. I would say some resolutions are on Sri Lanka, some resolutions are against Sri Lanka, some resolutions has been co-sponsored and shared by Sri Lanka, and finally some resolutions are withdrawn by Sri Lanka. So I think these different characteristics of the behavior of the state says that our state practice in terms of implementation and domestication of international human rights at the domestic level has been quite varied, sometimes depressing and disappointing. So with that, how can we include these international legal obligations undertaken by sovereign state in the domestic level can be linked with the constitutionalization of those obligations? So as Professor very correctly pointed out, now, even when we are teaching in our public international law class, both at the undergraduate and postgraduate levels, we used to bring Netherlands as a strong example where international obligations can be directly invoked by the people before the courts when their rights are under violation, right? So as being this international inheritance as a Commonwealth country, a former colony of the British Commonwealth, we still try to maintain the supremacy of the legislature, but our constitutions very correctly say the sovereignty lies with the people, not on one institution rather than the other. Therefore, the Constitution of Sri Lanka correctly say sovereignty of the Democratic Republic Socialist Sri Lanka is lies with the people, and the sovereignty of the people are, implemented by the legislature, the executive, and the judiciary. So then I don't think the legal system cannot be hampered, and the sovereignty of the people cannot be restricted by the set constitution, because these entrenched provisions very clearly can be spelled out on the benefit of the people of the country. However, I think we have a further way to go in certain different judgments, as well as something like what Nalaratnam Singarasa versus Attorney General, because that very clearly the judges were trying to say the supremacy of the legislature than the balance and the interface between the three important organs of the government. So where the judges of the Supreme Court themselves are kindly giving more way to the legislature than trying to implement the international obligations undertaken by the state at a time when the legislature is either lethargic or taking longer time to implement their international obligations by way of adopting enabling legislations. When you take, for an example, answering to your question, Mr. Akalanka, that V5, Sri Lanka being a state party to 4 Geneva Conventions of international humanitarian law of 1949, somewhere in 1950s. but we took extra undue delayed time to pass the enabling legislation, that is the Geneva Conventions Act of 2006. That you understand that from 1950s to 2006, we have taken extraordinary time to pass our enabling legislation. Again, that we find the enabling legislation is very much brief, not incorporated main humanitarian law obligations in our domestic Geneva Conventions Act. At the same time, there's another further caveat that it says this act will come into entry on a date the minister of the subject will gazette it. So from 2006, now we are in 2026, the relevant gazette notification is not issued. So these are some of the gaps, hindrances of a legal system which follows dualism. But the matter why that this come across there is no any kind of a interface between the legislature and the executive in terms of being a state party to an international treaty. The executive branch by its own undertakes international obligations. So there could be systems of governance. The executive is elected from one political party and the legislature could be elected from another political party. We have some past experiences as such. When the executive branch undertakes international treaties by ratification, then the legislature might do not take any serious note of implementing it by adopting necessary piece of legislation. So these kind of gaps are there. But at the international level, this country, the Sri Lanka as a sovereign state, is under an international obligation to duly discharge its responsibilities. That is how our domestic human rights standards are measured using our own international legal commitments coming through treaty law or customary international law, whereby treaty law mechanisms or charter-based mechanisms of human rights, they might find there is a gap between international standards undertaken by Sri Lanka and domestication of the same. So then we are under international scrutiny. So we are under name and shaming. So we are under a lot of constant inquiry. So I think this implementation of international law, particularly human rights standards in domestic law, has been a problem in Sri Lanka. So I think this is a serious matter to be noted. But we know developments occurred in the Commonwealth Community of States, particularly for an example, this Bangalore Principles, where judges of Commonwealth countries got together and they discussed their countries being dualist countries, but there are problems in implementing international law obligations due to the lethargy or other reasons of the legislative branch or executive branch. So this reluctance should not be passed to the people who are expecting the benefits coming from international law. So then they decided, well, to creep towards monism. Good examples are India, cases like Visakha versus State of Rajasthan. Then you can get many examples from Australian High Court, especially I think Justice Michael Kirby. In many of other cases like Get Rich case or Tower case, and many cases, he said, when our domestic law is silent and when there are international obligations, particularly human rights obligations undertaken by our own state, so then we have no barrier to implement those international obligations in the absence of a domestic enabling legislation, but by judicial activism. These things can be taken as example, but those itself will not be sufficient to give the benefit to the people. So constitutional recognition of international standards is very vital. So then we have to have a proper implementing mechanism of international human rights standards at the domestic level. But I have to say, in Sri Lanka, people are rather skeptical about international investment treaties when those are implemented without the filtering process of the legislature, because sometimes there could be certain investment treaties to which the executive branch may become a party without proper consulting the legislature. So those will be taken over of national property, some of, giving the property to international investors under unhealthy conditions. So those will be very detrimental to the sovereignty of the people. Therefore, we should have kind of a balance between international investment law treaties, how that they will become part and parcel of domestic law, whether it should be with or without participation of legislature. But on the other hand, when we look at domestication of international human rights treaties, so I think even though the members of parliament who are the representative of the people, who are answerable to people, who are the representative of the people to execute the sovereignty of people, when they are not doing that, so whether the disregarding the delay of the legislature, whether the courts, the judiciary should come forward to address that delay. So these are very important. So the constitution should carefully think about this striking features as well as conflicting of interest. But my argument is the benefit should go to the people at large, but that has to be done through a careful provision being recognized by the constitution. Thank you. I think the audience might be expecting more clarification from a very learned, world-renowned professor, Professor Noel Kemper. We are very grateful and privileged, Professor, to have you in and to have this very clear and thought-provoking presentation by you. Once again, thank you.
So we would like to welcome any questions that the audience may have. I hope this is a great opportunity for you to get any clarifications that you would like.
Yeah, Dr. Kokila has raised hand. Please go ahead.
Thank you, Akalanka, and thank you, Professor Vasanta. And thank you very much, Professor. Your very interesting legal analysis. I would agree with you on many points, but there are certain disagreements as well. I would like a clarification on those. First of all, I should say that true, I agree, supremacy of international law would be a very delightful idea. But if I may, coming from the post-colonial critique and also with my understanding in environmental governance from the perspective of North-South dimension, the origin of the international law or the lawmaking process of international environmental governance particularly would raise questions that the voice of the developing countries' perspectives are not properly, I would say, or are not clearly heard at the governance process of international lawmaking. So the international standards would reflect, I wouldn't say bias, but more voice and the concerns coming from the North than from the South. This may be debatable, but I would like to hear from you. So therefore, what if I would say that at least from the developing countries' perspective, to have the state sovereignty, whether we like it or not, whether it may not be our deliberate choice as a colonial country after British. So whether we like it or not, wouldn't it be a better choice from the developing countries' perspective? So because the international law in most of the cases are not principles, concepts and laws perhaps accepted to particular communities and particular countries. In addition to that, I quite agree with you about the judicial review, and I was amazed by your analysis on the Sri Lankan legal jurisdiction judicial review, particularly Bulankulama case. And I would also like you to invite you to read a latest case on environmental protection, which was decided in November 2020 by the Court of Appeal of Sri Lanka, that is Center for Environmental Justice versus Conservator General of Department of Forestry and others, in which again these international legal principles were highlighted by the Court of Appeal. And in addition to that, I would also like to highlight the point that in the current existing Sri Lankan Constitution, Article 2715, that is under Chapter 6, Directive Principles of State Policies, very clearly mention the Sri Lankan state. The state shall promote international peace, security, and cooperation, and the establishment of a just and equitable international economic and social order, and shall endure to foster respect for international law and treaty obligations in dealing among nations. So this is not justiciable, but at the same time, in the case that I just mentioned, it is famously known as the Vilpattu case. There are, and also another case before that called Chunnakam Power Plant case. In both of these cases, in Chunnakam Power Plant case, the Supreme Court, and in Vilpattu case, Court of Appeal very clearly mentioned that directive principles should have some guidance in state policy making. So why not this provision 2715 has some powerful interpretation by the judiciary. So pointing out those 2 points, again, I would like to thank you, and I would seek further clarification on my first point. Thank you so much.
Do you want me to address it directly?
Yes, my first
Yes.
point.
Yes,
Yeah.
yes. No, this was a very good point, and you're right that historically, indeed, many states that have opted for dualism, certainly after the Second World War, have done so in response to the rightfully deemed lack of legitimacy of much of international law and the process of international law making. And there's a clear historically identifiable trend between decolonization and the changing relationship between international law and domestic law in many states, where basically domestic law provided a safeguard against the injustices of international law. And that indeed, I had this one slide on the lack of rule of law quality, legitimacy of international law. And actually this particular point can be brought immediately in that same category. Still, having said that, when I reflect on the long-term interest of the international community and the need, the critical need for proper international regulation of problems of climate change and the like, I do not think that a continuation of the present shortcomings in the process of international lawmaking, combined with a dualist relationship between international and domestic law, is the ideal way forward. So ideally, and I realize that this is indeed some form of idealism, but there will be a combined track forward where the international community would, in a much better way than now, provide a strong and equitable role for the Global South in the process of lawmaking, like we have now seen in COP26, which in many respects I think was not satisfactory. on the one hand. And once that process works and we see a more equitable process of international lawmaking, that could also be a basis for a wider opening up of the accommodation between international law and domestic law. And these things are necessarily entwined. And even though I believe in this progress as a long-term perspective, I'm also realist enough, if we look to the process in Glasgow, that this will not happen overnight. And that indeed it would be too simple to say that international law is all just and good and all should be given supremacy of domestic law. And there might be legitimate reasons for domestic legal systems to include certain safeguards that might justify preclusion, giving full effect to international law.
Thank you so much for your clarification.
Yes, we may be able to entertain one more question, considering the time that we have left. So it is still, yes, I guess if the audience has one more question, then we may be able to entertain that. All right. So I guess in the absence of any further questions, we can conclude today's session.
It has been a long session also, I note. Yes.
Yes, and I must thank you very much for that, because I have to admit that we learned quite a lot, and it was truly amazing for us to have this kind of a thought-provoking session with you, because we always used to talk about monism, dualism, and how the countries have adopted without really going to a critical analysis as to what are the basis for doing this. We can draw up examples from different jurisdictions, but why these examples are drawn and how to justify and to evaluate those examples, I think today we really got a broad understanding as to why this is the case. And especially, even I can remember when we were learning about the relationship between domestic law and international law, Netherlands was taken as an example, but without really knowing why Netherlands has taken such a stance on the relationship between international law and domestic law, and also why it might not work from a Sri Lankan perspective to directly apply such kind of a mechanism. And today, I think with the insights that have been given, we are well off to critically analyze the situation and to compare situations and to come up with the best alternative that might best suit the country. And for that, I must thank you profoundly for accepting the invitation and having a prior meeting with us and coming and doing a session for almost 2 hours. For that, I must thank you again, Professor Noel Camper, Dean, School of Law, Amsterdam University, and I must also thank Professor Vasanta Seniviratne. I know that she had a very busy schedule today. She had to go and give her opinion to a special presidential committee, I believe, and after that she soon join. And also, I would also like to thank Dr. Sampath Puntihewa, Dean, Faculty of Law, for always being with us. And I want to give this to you. We will be again having another webinar, hopefully by January, on international law of the sea with again another profound scholar. And for today, again, I would like to really thank Professor Andre Noel Camper, and we know that we have some other discussions to do as well as we have discussed before. So we will hopefully fix the date for that as well. And with that, I wish you all the very best, and all the others stay safe, and we will meet again. Thank you so much.
Thank you, sir. Thank you. See you soon.
Thank you very much. Thank you.
Thank you, sir.
We
Some
look
Great pleasure to
forward to
participate.
meet you in Sri Lanka if the situation would be conducive. The law
I will be
faculty.
I will be
is-
delighted if that will be possible.
Thank you.
Thank you very much for the opportunity to speak to you. Thank you.
Thank you, sir.
Bye-bye.
Thank you. Bye-bye. Bye.
Bye.